Congratulations, you finally registered your Delaware Corporation. There are 7 specific things that you must do after registering the corporation to make sure that the organization is good to go. I've listed all 7 in my previous video. If you haven't watched that, pause this one, go back to that one, and watch the video from beginning to end. I've also included a list of those 7 things in the description of that video. Feel free to read through the description instead if you just want highlights of what that video says. Watch that, come back here, and this one will be good to go. In this specific video, we are focusing on one specific thing, which is handing power from the incorporator back to the corporation itself, or in this case, the board of directors. There's a specific way to do this, and in this video, I'm going to take you step by step on how to do that so that the board members, usually the co-founders, have power to then go forward and issue shares, create an EIN, and several other things that the corporation will need to do. Ready? Let's get started. In the accompanying article to this video, I have included a link to the documents I'm going to be using here. So go to the description, just click on that link, and then download this document that I'm going to be using here. I've created templates that you can use for all of this so that it's easy for you to do. You just need to follow step by step. I'm also going to give you a brief insight into the accompanying law so that you understand what you're actually doing. But again, this is not legal advice. This is information, public information. So you can go read the laws yourself. But I'm trying to just make it very easy and simple for you to understand. If you want specific advice on your specific case, feel free to send us an email or leave a message in our contact form, and I'll get back to you as soon as possible. So we can also review this document if you want. We have a service where people can upload documents, legal documents they want us to review, and we'll take a look through it, redline it, leave comments on it, and send it back to you when it's good to go. So if that's something that you want, feel free to explore that on our website. Let's get started on this. So this document is pretty simple. It's a very easy document. And so you'll go to our website and you'll download one of these. Check the description for the link. You can go over to that link and download this document. So I'm gonna come here and download this Microsoft Word to make it editable. This assumes that you've already set up the corporation. All you will need to do is come here and fill in the details, that's all. So if I scroll through here, you can see that it's just 3 specific things here in the resolutions. And then something we have to fill here, the name of board members and the name of the company. So let's take it from top to bottom like we typically do. So I'm gonna come here, and company name will go with the company that we formed in our first video on incorporating, which is Curry Genesis Inc. So let's come and put the name of the company here, Curry Genesis Inc. So we have that there. I typically like to have this in all caps up here. So let me just come here and make it all uppercase. There we go. And make this better. All right. So Curry Genesis Inc. Organizational action by sole incorporator. I was the incorporator in that video, so I'm gonna put my information here. So I, the undersigned, being the sole incorporator of company name. So I'm gonna replace this with my name. And that is Maranatha Curry. I, being the sole incorporator of, okay, company name, not my name. So that will be Curry Genesis Inc. A Delaware Corporation, the company acting by written consent without a meeting pursuant to Section 108 of Delaware General Corporation Law, do hereby consent to the adoption of the following resolutions. Now, this law gives the incorporator the right to do certain things, 2 very important things, and then there's kind of a broad or a vague power somewhere in there, but the 2 things that you can do and you'll be sure of. And if you want to do the third one, go consult with an attorney, because depending on what you're trying to do, you may not be legally empowered to do it. So it's typically better to do the 2 specific things that you have the power to do and allow the board to do anything else that you think is important to do. The 2 things that you're allowed to do is, 1, you're allowed to adopt the first bylaws of the company. The bylaws are the documents that list the powers of the managers, lists the powers of the board, the shareholders. It does all the boring bookkeeping, rather housekeeping work that is necessary. How to set up meetings, where to set up meetings, what notice must you give to the shareholders or to the board members. All of that goes into the bylaws. It's a very, very important document. And typically for most KYC requests, when someone is asking you about the company or they want to see information about the company, they'll typically ask you for the certificate of incorporation and the bylaws of the company. So it's a very important document. The first resolution here then says that resolved that the bylaws of the regulation of the company in the form attached hereto as Exhibit A, the bylaws, are hereby approved and adopted as the bylaws of the company. Now, lawyers do this differently. Some lawyers have the bylaws already good to go. In that case, what they'll do is they'll attach it here. You'll still have to ratify it later. So after you've handed power over to the board will still have to go through and ratify the bylaws ratify the adoption of the bylaws that is adopted here. So you could do that here, or you could just do that later with the board. I prefer to do it later with the board. And I want to make a separate video about the bylaws, what to look for, how to adopt them, what to add to the templates that we have, and do a deep dive. It's a very important document, so I want to do a deep dive on that. Rather than doing that first and then doing this, let's make this very simple. And typically I remove this clause anyway. I typically do the bylaws, anything that has to do with the bylaws, in a separate document with the board of directors. So kind of reduces duplicate work as well. So I'm going to remove this clause from here. This resolved, I'm going to take this out and leave that for the board of directors to do later. So let's go there, resolved. All right. So the next one is resolved that each of the following persons or the following person is hereby elected to the board of directors. In my case, there's only one founder, right? So I'm going to put resolved that the following person. But if you had two co-founders, you would leave the other side of the clause or the phrase. But here we only have one founder, which is me. So I'm going to delete that. Resolve the following person is hereby elected to the board of directors of the company to hold such office until the first annual meeting of stockholders, or until such person's successor shall have been duly elected and qualified, or until such person's earlier death, resignation, or removal. It's self-explanatory. And then here I'm gonna put my name, Maranatha Kure. And I typically like to bold this. All right. Resolve that the undersigned hereby resigns as the sole incorporator of the company, and the powers and duties of the undersigned sole incorporator be and hereby are terminated. So this basically says that now I've handed over power of the company from the incorporator, myself, to the new board members, coincidentally in this case myself. If there was an attorney doing this, what the attorney would do is they would resign as the incorporator, but they won't be a board member. So they'll be handing power directly back to the founders. And then signature page follows. I'm going to delete this and to keep things simple. And then I'll just move this up here so that the signature page is on the same page. Let's see. Okay, that's not moving. So if you were, I'm gonna come back to this, but if you were adopting the bylaws here, this is where you would adopt it as Exhibit A. And since we're not doing that, I'm just gonna delete this from here. All right, and then maybe to make this simple, I'll just copy this and paste it here. Let's see why that's not working. formatted text. All right, so we have it here, and let's just give this guy some space. Okay, so in witness thereof, we can then delete this if we want to. Now, the reason why it's typically on a second page is because, like I said in my previous video, if you have one or more than one incorporator and you want to have this document be executed by two different people without them having to wait for each other, what you can typically do is you can send two individual pages to two different people, right? And then have them sign those individual pages and send back to you. Once they send it back to you, you combine them into one PDF, and now it's one document. So allowing that space there makes it clear to whoever is reading the document that there are individual signers and they didn't sign at the same time, but they're all signing to one document. It's called putting a signature in escrow. There are two documents out there. Once they bring it back to you, you hold it in escrow. Once you have everything from everybody, you combine it into one document and you submit it. But in this case, it's just me, so I'm just not gonna do that. All right, so then I can come here and put today's date, which is May 3rd, and then put my name as the incorporator now, Maranatha Kure. And then I'm going to just take a final look at this, see that everything is as it should be. Duly executed this organizational action by sole incorporator as of May 3rd, 2024. Looks good. So we'll just save this as file, save as sole incorporator, just so I know which one. I'll put Create Genesis here. And then from here, it's straightforward. You can do this any way you want to do it. But a good way to do this is, or one way to do it rather, is you save it as PDF. And then you can either, if you already have a digital signature saved, you could add your digital signature to this directly. If you don't have a digital signature saved, you could put this on a service like Adobe Signature or DocuSign. Send that to yourself and then you can sign it. But so there are different ways to do this, or you can print this and sign it physically. When I'm doing this with clients, what I do is I put it on DocuSign typically, and I send it to them via DocuSign for them to sign. Makes it more formal, and it creates a signature trail that anybody in the future that wants to do due diligence on the company, they'll find each specific action and can track exactly how it was created and executed, so that there are fewer issues, legal issues with this down the road. But this is what it looks like. So I'll just add my signature here, or put it on DocuSign, send it to myself, and do the same. If you have any questions, leave a comment in the comment section, or shoot me an email, or leave a message in the contact form, submit it, and one of us will get back to you. Thank you guys for watching. I'll see you guys in the next one. Bye.